here in Canada, you have to, before you go to trial, you have to go to a pre-trial. And a pre-trial is where they come to an agreement about the parameters. And it's totally determined by the judge, but the parties have to agree with the pre-trial judge. And subject to Civil Practice Note number 5, subsection B, 6A, there has to be an agreement made concerning exhibits. And there was an agreement made concerning exhibits at my trial. And however, I was ambushed with new exhibits that were not within those trial parameters. And to top it all off, the new exhibits could not be produced. They couldn't even be adduced because the new exhibits my wife brought into trial, they were documents that were never properly produced into the action. So they can be produced pursuant to Alberta Rule of Court 158.51E, which means that which states that any documents properly produced into the action. Well, my wife produced documents into the action, and I didn't even get a chance to review the documents. I asked Justice Horner, I said, hold on here a minute, let me do this. But no, there's no way Justice Karen Horner wanted me knowing what those documents are all about while I was actually being served, while she just finished questioning me on the, or cross-examining me on the in the witness box, and all of a sudden I'm still sitting there in the witness box, and all of a sudden I'm being handed these new exhibits while I'm still in the witness box. I don't even get to review them. And the thing is, that was totally in violation of the Canada Evidence Act. Sections 28.1 and 28.2 of the Canada Evidence Act. And the Canada Evidence Act is an act respecting witnesses and evidence. And the reason why I was deprived the Canada Evidence Act sections 28.1, which states no copy or any book or other document shall be admitted into evidence under the authority of sections 23, 24, 25, 26, 27 on any trial, unless the party intending to produce the copy has before the trial given to the party against whom it is intended to be produced reasonable notice of that intention. Well, I wasn't produced any reasonable notice of that intention. You're supposed to have this all sorted out at pre-trial, and in the pre-trial material that my ex-wife had, Rhonda Sales, it didn't have those. She had a complete, totally different set of exhibits that she produced at pre-trial. And then sections 28, section 28.2 of the Canada Evidence Act states that not less than 7 days. The reasonableness of the notice referred to in subsection 1 shall be determined by the court, judge, or presiding, or other presiding person. But the notice shall not in any case be given less than 7 days. And what I was served, I was ambushed with these new exhibits that were emails that I sent. I didn't realize that these were genuinely bona fide emails sent by me, because, you know, I had my computer blow up or whatever, and, you know, who's going to remember emails that they sent like two and a half, 3 years ago? All of a sudden you're being served this. It's like, are these your emails? And I was deprived the opportunity to answer properly. I gave the wrong answer, or I said, I can't recall this. And then, you know, I have memory problems because I do have MS. So I was also deprived sections 6.1 and 6.2 of the Canada Evidence Act. 6.1 states, if any witness has difficulty communicating by reason of physical disability, the court may order that the witness be permitted to be given evidence by any means that enables the evidence to be intelligible. Well, I have physical damage to my brain caused by MS attacks. Medical documented history ever since back when back from like March of '99. It was medically documented by a neurologist. And they did an MRI scan. And then I just had a recent MRI scan back last July, and it's showing that my lesions in my brain are getting worse. And then I was also deprived Section 6.2 of the Canada Evidence Act, an act respecting witnesses and evidence. Section 6.2 states, if a witness with a mental disability is determined under Section 16 to have the capacity to give evidence and has difficulty communicating by reason of disability, the court may order that the witness be permitted to be given evidence by any means that enables the evidence to be intelligible. Well, I have short-term recall problems. That is what that's a notorious problem with people that have MS. When it attacks their brain, it's short-term recall problems. I do have short-term recall problems, but however, my long-term memory is well intact. Well, when you see in the video of Justice Horner here, you'll actually see that I wasn't given even a moment. You can tell that Justice Horner did not want me to even see the exhibits. Well, she didn't want to give me even a moment to look at them. I said, here, give me a moment, and then she sidetracked me. You'll see in the video. And but before we do that, I'm going to actually let you listen to the pretrial parameters as what was expressed by Justice Bonnie Rawlins at pretrial.
So we're good to go. You're here on the 17th and 18th of May then?
Yes,
10 a.m.? Okay.
And also
do not bring in, that's fine. We've got your witnesses. You're both going to do that. There'll be no surprise witnesses. All your disclosures should be there. Everybody should have, well, I guess whatever documentation you have to trace the funds is what you're going to need to show the trial judge. Okay? Trace the funds from however many houses you all